Okay, so now we're live, transmitting to YouTube, and I'll begin by introducing our esteemed panelists. And starting by Aécio Oliveira, he has a master's degree in international private and commerce law achieved in the University of Paris, Panthéon-Assise. And today he works as a foreign associate at WilmerHale in London, dealing with arbitration. And Adriana Braghetta has a master's and a doctorate achieved in the University of Sao Paulo. Today, she is a member of the governing board of the ICC, and she also leads her own practice in Brazil.
ICCA.
Yes, ICCA, sorry. Dr. Florian Mohs is trained in both civil and common law jurisdictions. He holds law degrees from Switzerland, being a doctor of law from the University of Basel, from New Zealand, having an LLM from the Victoria University of Wellington, and Germany, having the first state exam in Baden-Württemberg. He concluded his legal studies at Albert Ludwig's University of Freiburg. He was admitted to the Swiss bar in 2008, and today he is a partner of the Pestalozzi Litigation and Arbitration Group in Zurich. So, seeing as we have a stellar panel which has dealt with commercial arbitration, specifically CISG arbitration in the past, I think this will be a great discussion on the issues of this year's moot. And now I will go on to give a brief overview of the main facts of the VisMoot, starting with the parties and their contractual history. So the claimant in this year's case is one of the largest producers of RSPO2 certified palm oil and palm kernel oil based in Mediterranean. Now the respondent, Yaya Biofuel, is a well-established producer of biofuel based in Equatoriana, which has been acquired in late 2018 by a company named Southern Commodities, which is a multinational conglomerate with its headquarters in Ruritania and trades in all types of commodity, including palm kernel oil. Until its acquisition in 2018, the respondent had only produced biofuel from other food crops, but it had been one of the objectives of the new management installed by Southern Commodities to expand into biofuels based on palm oil. For a long time, the claimant had sold 2/3 of its annual palm oil production under a long-term contract to a single customer. Following the changes in the attitude to palm oil-based biofuels in the European renewal as established in the European Renewable Energy Directive, and confirmed reports that 2 claimant suppliers had forged sustainability certificates, the customer terminated its supply agreement in January of 2020. As a consequence of that termination of the long-term supply contract, the claimant had to find a customer for 2/3 of its production of certified palm oil on a very short notice. With that in mind, Mr. Chandra, the claimant's COO, used the Palm Oil Summit in the capital city of Mediterranean to approach Ms. Bupati, the head of purchasing for the respondent, to sell this palm oil. Ms. Bupati had been for a long time the main purchase manager for palm kernel oil of Southern Commodities. In that function, he concluded around 40 contracts with Mr. Chandra for palm kernel oil between 2010 and 2018. With this acquisition, the respondent and the centralization of the palm oil activities, Southern Commodities had installed Ms. Bupati in 2019 as head of purchasing for the respondent. Given this favorable prices offered by the claimant for a long-term commitment, Ms. Bupati showed great interest in purchasing the entire available production of palm oil from the claimant. and this contract would be for 5 years. In principle, Mr. Chandra and Ms. Bupati managed to settle all commercial terms in their negotiations at the palm oil summits in light of the recent controversies concerning the respondents' palm oil business. Ms. Bupati wanted to get approval from the respondents' management first before entering into such a long-term, a 5-year commitment of this considerable size, given the size of the negotiations. So it was agreed that Ms. Bupati would get back to Mr. Chandra with a definitive offer within the next 3 days. And then they would prepare the contractual documents that was, and this was, just to get this clear, this was the mode of operation which Mr. Chandra and Ms. Bupati had established for their numerous palm oil kernel contracts during the years of 2010 to 2018. Afterwards, Ms. Bupati sent an email ordering 20,000 tons of RSPO certified palm oil per annum for the years of 2021 to 2025, just as has been agreed upon, to be delivered in 6 installments every year, starting in January 2021. These were the commercial terms agreed between the parties at this palm oil summit. Mr. Chandra had his assistant, Mr. Rain, prepare the necessary contractual documents in line with the practices established with Ms. Bupati in the last 8 years of contractual, in the last 8 years of these 40 contracts that had been negotiated before between these same representatives. The contract was based on the claimant's contract template into which the details of the offer were incorporated. Mr. Rain sent the contract signed by Mr. Chandra to Mrs. Bupati's assistant, and Ms. Falconer, the accompanying letter, and Ms. Falconer. The accompanying letter to this contract explicitly mentioned that the contract would be governed by the law of Mediterranean and that the purchase would be subject to the claimant's general conditions of sale. And this is important. The general conditions of sale were not included in the letter or the document sent. It is, however, uncontested that Ms. Bupati had received the copies of the claimant's largely identical pre-2016 general conditions of sale in 2010, when she was still working for Sudden Commodities, and had at least been informed orally by Mr. Chandra in 2016 about the changes to the arbitration clause and their background. In addition, the letter named Mr. Rain as the relevant contact for all questions concerning the contract and asked for the return of one of the signed versions for the claimant's files and the necessary paperwork for shipment. Afterwards, Ms. Falconer contacted Mr. Rain to set up a meeting to discuss issues concerning the letter of credit which the respondent was required to open under the contract. She asked for a list of acceptable banks and wanted to clarify the documents to be presented for payment. In the call finally agreed between them, Mr. Rain pointed out that so far no signed contract of the copy had been received, and Ms. Falconer promised that she would look into that. A signed copy of the contract was never sent, and in light of the fact that the previous transactions conducted by Ms. Bupati for Sudden Commodities, she had not always returned the requested signed versions of the contract. The claimant was not worried about this fact that it was not signed and did not follow up. That all changed in October 2020, when the claimant learned from an article in Commodities News that the respondent's CEO, Mrs. Unilever, had announced in a press conference that in light of ongoing protests against the respondent's palm oil activities, the respondent had stopped all further negotiations with the claimant concerning the delivery of palm oil and was potentially reconsidering its palm oil-based biofuel activities. So Mr. Chandra, with this news, immediately called Ms. Bupati trying to clarify this issue. He told her that she was on holiday, that he was on holiday, and but would call him back upon her return. The next day, on the 30th of October 2020, the claimant received a letter from the respondent CEO, and in that letter, Ms. Lever declared the termination of any further negotiations on the delivery of palm oil, and additionally renounced all existing contractual relations, allegedly to disinformation about the claimant's infringement of basic RSPO standards. 4 days later, Ms. Bupati finally returned to Mr. Chandra's phone call and confirmed the content of the letter and suggested that Mr. Chandra discuss the issue with the respondent's COO, Mr. Fortif. So, seeing as in this case, and the communications stop right there, in this case, one of the main issues is the incorporations of the general conditions of sale. The contractual documents sent by the claimant to the respondent clearly state that the contract is subject to the claimant's GCOS. The contract itself provides in the last line of the header box, seller's general conditions of sale apply. Furthermore, Mr. Rain's email explicitly mentions that the general conditions of sale apply to issues not regulated in this. And this will be a key fact in dispute. It is not disputed that the GCOS was sent to Mrs. Bupati when she was working for Southern Commodities. But it is an issue if it would be applicable in view that Ms. Bupati did not have access anymore to the GCOS, and that it wasn't explicitly agreed upon in a signed contract in the present negotiations. So the contractual documents, as well as the letter accompanying them, clearly state that the contract should be governed by the claimant GCOS. But this current GCOS was not provided to the respondent, not to the subsidiary that was acquired by Southern Commodities. But Ms. Bupati was indeed orally informed about the relevant changes in relation to the arbitration clause, which was one of the minor changes that was made to the GCOS. So, having done this brief introduction to the main facts of the merits of the case, the issues that will be discussed in this webinar is the formation of contracts under the CISG. And this is what is a valid offer, what constitutes a valid acceptance, especially in view that the contract wasn't signed, it was only orally agreed to and by communications in email. Furthermore, we shall also discuss the standard terms and the validity of the inclusions of the general conditions of sale into this contract, in view that these general conditions were not in view of the fact that Ms. Bupati did not have access to the general conditions of sale, and that there were minor differences between the general conditions of sale used by Southern Commodities and the GCOS used right now. And last but not least, we shall also discuss what the difference is between the common practice between people and the common practices between parties. This is relevant to this case because in this case, we have one representative that served for the controlling company and now for the subsidiary. And he conducted negotiations in much the same way, in much the same terms. So would the actions of this representative, and can a common practice be established between these parties that have no preceding business agreements, but actually between these representatives that do have preceding business agreements? Can a common practice be therefore established? And is there any legal support for the establishment of common practice between people that can bind the parties involved? So Now on to the presentations. Dr. Aécio will now give a presentation on the formation of contracts under the CISG, addressing these issues.
Hi, everyone. Good morning to those who are in Brazil today. First of all, I'd like to thank you, CGA, Comitê de Jovens Arbitralistas, and CBMA, Centro de Brasileiro de Mediação e Arbitragem, for this kind invitation. For me, it's a pleasure to discuss a little bit further CISG with such prestigious colleagues such as Adriana and Florian. This webinar is being broadcast through YouTube, so for those who are watching us, please give your comments, questions. I'm sure that Daniel will try to address it here during this panel. I'm responsible today to discuss, as Daniel said, the formation of contracts under the CISG. Daniel has already provided us a brief summary of the case, and I will not try to address it here. I will rather give some introduction to the CISG and to the formation of contracts itself. As to how this brief presentation is going to be divided, first, I will give a brief introduction as to the matter. Then we will discuss what is a valid offer, what is a valid acceptance under the CISG. And finally, I would like to discuss Article 19.3 due to its significant relevance that it reached due to this VisMoot year problem. So as a matter of introduction, it's worth mentioning that a contract of sale under the CISG has no formal requirements. It means that it can be proved by email, proved by witnesses, by writing, any other means that the parties can demonstrate that it was a valid offer, a valid acceptance, and then resulting in the conclusion of the contract. As to the CISG itself, it has a part 2 that expressly addresses the formation of a contract. It contains 11 articles. All of them are based on the traditional premise that a contract is formed by means of an offer and by means of an acceptance. Article 14 to 17 deals with the offer. Articles 18 to 22 will address questions regarding the acceptance. And finally, Article 22 and 23 will answer when a contract is considered as validly concluded. So as to the first issue of what is a valid offer, we may need to first inform what are the difference between an offer and a proposal under the CISG. Then discuss a little bit about what are the requirements for a valid offer. And finally, assert what is when the offer is considered as effective. To the first issue, so what are the difference between an offer and a proposal? Article 14.1 and 14.2 give us a clear view of their difference, while Article 14.1 will express what will be an offer under the CISG. Article 14.2 would rather say what would be a proposal. And when we read both articles, we can see that the main difference is to whom that invitation to make an offer is addressed. While an offer under Article 14.1 will be addressed to a specific person or people, a proposal under Article 14.2 would be addressed to undetermined people. And with that in mind, we can see that when we're dealing with an offer, we can have a clear manifestation of the will of the parties. And as a result, a mere acceptance of the offeree would be enough for the conclusion of the contract. On the other hand, when you're dealing with a proposal, that clear manifestation of will is not expressed. And mainly considering that normally the terms of the condition are still subject of change. That is clear what happens, for instance, when we have advertising circulars, catalogs, and price lists. And the language used in Article 14.2 was clearly intended to demonstrate that those type of communication shall not be considered as an offer. having that in mind, so when having this difference made clear, we now need to understand what are the requirements of an valid offer. Well, for that, I will read again Article 14.1 that shall be used as a base for this understanding. And I will quote, "A proposal for concluding a contract addressed to one or more specific persons constitutes an offer if it is sufficiently definitive and indicates the intention of the offerer to be bound in case of acceptance." So in sum, Article 14.1 lays down two main requirements. First, the offer needs to be sufficient, definitive, and it needs to demonstrate the intention of the offerer to be bound. As to the first requirement, scholars demonstrate that sufficient definitive shall means that the offer needs to have the terms of the good in question, such as describing the form, color, and quality, the quantity, the price, the duration of contract. As to the specific matter regarding this first requirement, one question may arise as to whether or not the parties can conclude a valid contract without specifying the price. Well, to answer this question, I believe we must first read Article 55 of the CISG, and I quote, "Where a contract has been validly concluded but does not expressly or implicitly fix or make provision for determining the price, the parties are considered, in the absence of any indication on the contrary, to have impliedly made reference to the price generally charged at the time of the conclusion of the contract for such goods sold under comparable circumstances in trade concerned." So some scholars may say that although the parties have not specified the price, it would still be possible to conclude the contract because they could make reference to the comparable circumstances in trade concerned. However, part of the scholars as well says that Article 55 of the CISG could not be read with Article 14.1 because it would only be applicable to contracts already concluded. As an alternative interpretation, I must quote Board Lead that he says that Article 55 could indeed be applicable just in those cases where the price, although not specified, are the parties nonetheless have agreed on or established forms to establish the price. So in that condition, in that case, would be possible to apply Article 55 and then concluding a contract without specifying expressly the price. As to the second requirement laid out by Article 14.1, it's in some a case-by-case analysis. And that's going to be really important in the VisMoot problem because the parties will need to try to refer to the arbitrators what were the wordings, expressions used in the emails and communications that demonstrate respond not only, of course, claim intention to be bound by the offer, but also the respondent's acceptance, as we're going to see afterwards. So, for instance, we need to see that clear state of commitment to the offer. And that language was clearly intended to avoid that offers, letter of intent, and memorandum of understanding could be seen as a valid offer because they are still subject of agreements and negotiations. The third issue that I would like to discuss regarding the offer itself is when it becomes effective. Well, Article 15.1 of the CISG gives us a straightforward answer that it becomes effective when it reads the offer. And at the moment, we may have three different scenarios. Either the offeree will going to accept the offer, so that is regulated by Article 18 of the CISG. Either the offeree will reject it, which is ruled by Article 17 of the CISG, or finally, it can present a counter proposal that is dealt by Article 19. As we considering this year's VisMoot problem, we shall pay attention or focus on the acceptance itself. So, what is a valid acceptance? When we read the VisMoot year's problem, as Daniel has advanced to us today, I believe that three main questions shall be addressed. Well, first, Is an agreement on the commercial terms by email, for instance, sufficient for the valid formation of the contract? In addition, is it necessary the receipt of a signed version of the contract for its valid formation, or the conduct of the parties enough? And finally, does party autonomy conflict with silence? Well, three interesting questions that will need to be answered during this VisMoot. At the outset, I believe that Article 18.1 will give us a first answer. I quote Article 18.1, it says, a statement made by or the conduct of the offeree indicating assent to an offer is an acceptance. Silence or inactivity does not in itself amount to acceptance. Well, from this article, we can see, we can have three different conclusions. First, either a statement or a conduct can constitute an acceptance, a consent to the offer. And the silence itself, there is not a presumption that it represents an acceptance. So the first question, I believe it's answered. An agreement by the parties by email would be indeed valid, would be sufficient for valid formation of the contract. As to the second question, if is it necessary the receipt of a signed version, I believe that all discussions regarding these questions are related to whether or not we have an unconditional consent. That is what Article 18.1 requires the party to demonstrate. If that unconditional consent is given by email, by the signed version of the contract, or by the conduct of the parties, that will be equally important for under the terms of the CISG. As to this unconditional consent, of course, we may say that it has an exception, and we're going to deal with that when we're going to discuss Article 19 of the CISG. As to question number 3, whether or not does party autonomy conflict with silence? Well, we may have some articles to consider. First of all, I believe that Article 18.3 deals with the problem of acceptance of the party. It expressly mentioned that although the party would not notice the offerer about the offer, if it has indicated assent by performing an act such as relating to the dispatch of the goods or payment of the price, then the act would be considered performed. But precisely regarding whether silence could be seen as this acceptance by conduct, we shall read Article 9.1 of the CISG that is quite important to this question. Article 9.1 of the CISG expressly says, and I quote, the parties are bound by an usage to which they have agreed and by any practice which they have established between themselves. We're going to have the opportunity to discuss it further, but the parties may try to demonstrate whether or not the silence of respondent was a commercial practice between the parties or between the people, as we're going to discuss later, and to try to demonstrate that that was an acceptance by conduct. Finally, regarding Article 19.3, as I said, as soon as we have an offer sent to the offeree, we might have 3 different scenarios. Either we're going to have an acceptance, either we're going to have a rejection, or we're going to have a counter proposal. And what I would like to say is what is considered an acceptance and what is considered a counter proposal. Well, Article 19.1 says that a reply to an offer which purports to be an acceptance but contains additions, limitations, or other modifications is a rejection of the offer and constitutes a counter offer. Well, but the question is, all kind of additions, limitations, or modifications are considered as a counter offer or a rejection? The answer is no. Article 19.2 says that those that are not materially to alter the terms are not considered as a rejection, and therefore the contract is valid formed. However, and what is really important to this year's problem, Article 19.3, on the other hand, expressly says that the quality, the extent of the one party's liability and the form of settlement of dispute is considered as materially alter the terms of the offer. Well, if we analyze the case records, one may try to assert that respondent did not agree with the party's liability and the form of the dispute resolution. So that's going to be an interesting discussion. But from what concerns my presentation is whether or not Article 19.3 raise a rebuttable presumption. I believe that it does not raise a rebuttable presumption as long as, of course, the offeree proves the alteration were immaterial by other means. And for instance, Christoph Brunner expressly mentioned that even the alterations named in Article 19.3 may be qualified as immaterial if the parties view them as such, and if such qualification derives from practice established between the parties. So in the end of the day, whether or not the Article 19.3 is a rebuttable presumption, parties we're going to need to assert what were the practice established between the parties. With that in mind, I thank you all, and I'm looking forward for the roundtable discussions that we're going to have. Thank you.
Thank you for your presentation, Mr. Aécio. And I'd like to ask if the other panelists have any considerations on the matter.
Starting with, may I jump in?
On what is the valid offer, of course.
Okay. First of all, thank you very much for the CBMA and the Young Committee of Arbitrators, the Comitê de Jovens Arbitralistas. It's a pleasure to be here. It's my first panel with a parrot at the end. I think you have a parrot with you, don't you, Daniel, or a kind of a bird that was participating in your presentation together with us. I have seen dogs, cats, but the parrot, a bird is the first time. And just to mention a little bit about the topic that Aécio discussed, I think it's interesting to see is that this CISG has chosen in Article 14.1 some conditions to be, has elevated some conditions to be enough for the formation of the agreement that are different from the conditions of Article 19.3, which is let's say, a change to an offer. And it's very interesting, this dual set of conditions. It may imply at the end that if you have reached consensus on the main terms, meaning price, let's see, 14.1. The products, the price and quantity, you have an agreement, and you may still have an agreement and not agree on other issues relating to the liability between the parties, which the arbitral tribunal may be asked to complement, and even the dispute resolution provision. So I think this differentiation, it's very important in this very well structured case. Let's take into example, for instance, the letter. You guys, you know the case in more detail than I do, but for instance, it attracted my attention, the letter sent by Claire Bupati, the first one, the offer. If the offer was, it's an offer. She says, you know, I'm placing an offer. I'm placing an offer, and all the elements of Article 14.1 are there. Imagine if in this case, Mr. Chandra on the other side would simply say, I agree with your offer. You're right. The general terms are the ones that you are thinking aloud, you mentioned. Most likely in that situation, it would be very clear for us to say, it's enough. We have an agreement. Obviously, the ambiguous facts of the case will entail a larger discussion. But from my point of view, Aécio and Cisg make it clear that you don't need the signed version of an agreement. The exchange of mails would suffice, and the conditions of Article 14.1 were there. The other conditions are a little bit tricky, especially the general conditions of sales that we'll discuss further on.
Thank you very much for the contribution. Does any other panelist have a consideration he would like to make, or can we go on to the standard terms and the valid inclusion of the general conditions into the contract?
Maybe also a comment from my side, Daniel. First of all, welcome everybody, and warm thank you to the organizers of this event, and particularly you, Daniel, but also CGA, CBMA for hosting this event. It's a pleasure to participate. My last time to Sao Paulo, at least, is a little while ago. Rio de Janeiro, the same. So at least I made it virtually. And yeah, very happy to discuss this year's mood problem with you. Well, when we speak about offers and acceptance, I think with regard to the mood court problem, it is of course also very important that there was a first discussion between the negotiators at this conference or summit or whatever it is called in the commodities industry, where they basically touched base and, to my understanding, already found basic agreement on the commercial terms. And, I understood the problem mostly to say that I think Ms. Bupati needed to receive board approval, right, for this transaction, if I'm not mistaken. So also, before we look to what is in the record in terms of writings and emails, let's not forget there was a substantial discussion orally between the main negotiators, and they seem to be quite advanced in their common understanding of the transaction, not only of the commercial terms, but also of changes to the general terms of conditions of the claimant, which is a bit surprising, because if you think about businessmen in general, you would assume they are focused on price, delivery terms, payment, maybe quality things, but not so much about applicable law or the arbitration clause necessarily. And here there seems even a discussion has taken place regarding those terms, which, again, looking to 19.3, as Adriana did, also indicates, one could argue, a certain importance of those terms, because otherwise they would not have made it to the negotiation table of the business people. We in our transactional business, I mean, you have the transactional lawyers who say it's all midnight clauses, right? The governing law, the arbitration clause, templates that get in last minute. And then you have the other extreme of transactional lawyers who say, I need to negotiate it first so that I know how to negotiate the contract, because it may be very different if I have Brazilian or Swiss law being applicable to a transaction. But yeah, I think that is striking to me. when I read the VisMoot problem, and yeah, I think that would be my, say, first set of comments or considerations.
If I may, sorry, Florian.
No, I was just wondering, how do we get questions? We getting them via Daniel, or?
That's via. I'll read the YouTube questions and I'll relay them here.
I didn't want to cut you, Aécio. I mean, please.
Okay, well, if I just may have one more comment. And as a follow-up comment regarding Adriana and Florian's comments, when we see the requirements that were laid down by Article 14.1, that is, as we said, price, the form, the quantity, etc., it's important to mention that those are the essential elements, right, for the valid formation of the contract. Because although even if there are no express agreement or terms of specific other terms regarding, as for instance, who will receive the good, where the good will be received, all of these terms can be easily settled by the application of the CISG. So that's an interesting point to see that those elements are essential to the offer, but other elements can be resulted from the interpretation of the CISG itself.
Yeah, one additional thought that I had when we discussed, and it came up in a few of the pre-moot sessions I have had, is, you know, this freedom of form under the CISG, contradicted by the fact that apparently both parties thought that the transaction would be recorded in writing, right? I think this first email of, what is it, first March or April, sorry, I'm not so into the details, I think says, I assume you will put that into writing and get it back to me, and then there comes back a one-sided copy of a written contract, which then is not countersigned. And the dispute seems to be, is this a mere formality that was handled by assistants, and sorry, formality, it got forgotten, nevertheless we shall and are obliged to execute the contract? Or is it much more, and is it a requirement put there by the parties that their specific contract is only valid once put into writing? I don't know what views you have, Adriana and Aécio, on that aspect of the problem, where parties, of course, can agree that, you know, a binding contract will be subject to being put into writing.
Florian, just to add a little bit to this end, I think you are quite right. I was also astonished by the fact that she, Miss Bubati, she requests for something in writing, some paperwork. And as I mentioned, the other would say, the other could say, Mr. Chandra, no, there's no need. We are done. You made an offer. But I think, and then we will jump into the second issue. I think the usage between the parent company in the past, nowadays I sit constantly as an arbitrator. And the fact that in the past, there were other similar situations in which one of the parties sent a version signed, the other party didn't send the assigned version of the agreement, but the agreement was implemented. So this is an established fact in the case. For me as an arbitrator, would be very relevant to say there's no need in this case. Although if it was a real case, I myself as arbitrator would say, let's take up a moment of pause to discuss the other issues. Obviously, we're not going to touch about the arbitration clause here, but it's very important also, as you mentioned, in a normal situation, the letter of credits. The claimant would never send goods if he's willing, it's willing to receive a letter of credit prior to send goods, without this issue being solved. And there's a lack of documentation in the case files. You see, some they were discussing some banks that they would agree, but there's no proof of a letter of credit being sent to claimants. In a real scenario, myself, I would put a lot of attention into that regard. So, you have started to implement the agreement by discussing a letter of credit, but what happened by then?
Yeah.
That's my comment to you. And Floria, not Floria, but I asked you, anything else?
Well, I totally agree with Adrian's comments. I mean, if we see that between 2010 and 2018, Mr. Chandra and Ms. Bupati concluded almost 40 contracts, and among them, they were not always concluded with the respondent sending the signed version of the contract. One may say that there was indeed a contractual practice between the parties and that was not mandatory at all. And as Adriana said, the respondent, that was, I think, is a good point. One of the reasons why the respondent was not able to send straight forward the signed version was that he still needed approval of its CEO, I believe. And in the end of the day, he got disapproved. And afterwards, as Adriana said, he tried to open a letter of credits. So all this conduct and this practice between the parties, I believe it might be used for the teams to try to point out that it didn't need a signed version of the contract, and there was established contractual conduct and practice between the parties.
Yeah, very, very valid points, and very difficult points, and points where facts play a big role, I would say. And if I may play the devil's advocate, what this mood is about, I would, of course, try to argue that, let's look at the letter of credit. I mean, of course, if I open a letter of credit with my bank, it's the first step in effecting payment, and it's for sure an indication that there is a binding contract if I start executing the contract. But if I have a mere discussion with various banks on what their terms are, and I need to check back with my counterparty, how exactly we would arrange for payment under the contract, could that not also be simply a continuation of the negotiations? It's not I would argue it's not a necessary conclusion that there is a binding contract because I discuss with my banks, right? I mean, you have various reasons to discuss with your banks, and I think there are certain indications on record that there was an annual or whatever, a quarterly meeting with the banks, and they discussed this possible transaction. So I think this is something to consider. And then I think that's also an issue we all had in mind to a little bit touch upon, is this past practice argument, which seems to be at the core of this year's problem, because Ms. Bupati, of course, has past practices with the claimant and Mr. Chandra, but that comes from a time when she was still working with the mother company, is my understanding, and that for the respondent, the daughter company, Ms. Bupati has not had so many transactions with the claimant, or it's actually the first transaction. So the question is, can we ascribe past practices of people, as we said, as a question for this discussion, to the companies? And that may be a very difficult question, because the CISG, of course, speaks of the party or the parties, and one may wonder whether or not companies transacting under the CISG can really be held to past practices of their employees, basically. I don't know if you have a view there.
May I jump in again? First of all, I agree with you, Florian. And if I were sitting in the case like this, the letter of credit, for me, it's detrimental to understand if it was formation of agreement, if it was implementation, because if it was a condition in the agreement for the validity of the agreement, let's imagine that generally someone that will deliver the goods would say, you need to provide me with a letter of credit in 30 days, otherwise I will not produce to you. So there's no proof in the agreement or in the files. So I totally agree with you. The mere fact of the existence of a letter of credit is crucial in this case, but we won't have enough information about that. In relation to this issue that you raise, it's quite a challenge to discuss that. Huh? My first reaction to that would say, I think we can, both parties can argue in both ways, and even the arbitral tribunals can decide in both ways. It's easy to decide in both ways. There are reasonable arguments to decide in both ways. One can easily say, the standard of the CISG is that you have to prove that you have sent a copy of the general conditions to the other side. You haven't proved that, it's done. I'm not going to pay attention to the fact that she was working for the mother company in the past years. Obviously, it's totally, I would say it's even possible and technical, this line of argument. But what came into my mind yesterday when I was reading the case and preparing for the session is that, first of all, there's no proper wording or clear wording in the CISG in relation to general conditions. I think this there is this majority of authors and commentators arguing, and case law. I think one of the cases I saw in one of the papers, one of the cases also saying there needs to be proof that you have sent general conditions or you have made available. But it's already some sort of interpretation of the CISG. There's no clear, let's say, legal wording on that on the convention. So I will give less importance to that evidence. I will give more importance to the rationale behind Article 8, with its consent and intent. I think when the authors and commentators suggest that you have to show that you have made available the general conditions, obviously what lays behind is that you cannot impose conditions that the other party is not aware of. You cannot create further burden to the other party to look out and to dig in and to find the conditions of the contract that you are trying to put together. So the fact that the party, the person that has authority And again, this is my prima facie view, and I'm thinking about this yesterday and today. The fact that Ms. Bubati, she has legal authority to bind the company. She is aware of the conditions themselves. I think it's possible, although we don't have probably case law on that, it's possible to say that the standard or the common practice between the parties can be, in this very specific case, can be, or it's not the parties, the usages all established between the parties, and then the parent company, the mother company, can be incorporated in this case. These are my general perceptions. But again, it's quite easy. It won't depend on how lawyers will present the case. It will depend on details. We will, as arbitrators, we would go back and forth on the documents. But most important for me is the rationale. The other party, one party say, no, I'm going to apply my general conditions of sale. The other party is aware of the general conditions of sale. So there is no lack of trust, or except for the arbitration provision, there's no improper understanding from one side what is the other side saying it believed the agreement should take into consideration. So for me, this is the rationale behind Article 881, I think, of the Cisg.
If I may, I share with Adriana's position, and precisely regarding whether we should consider whether a common practice between people rather than party would be a problem to this case. As Adriana said, we may remember that Ms. Pupati was the general condition of sales of the southern commodities, and then it became the head of purchasing. She became the head of purchasing of respondents afterwards. So she had definitely had the legal powers to act upon and represent the parties in both scenarios. And when we see whether the terms were made available, well, of course, it's uncontested that the oldest versions of the general conditions were made available. But however, it got changed in the latest years. But when we see those changes, the teams may also address that Ms. Bupati was made aware of those changes, either by conversations and then by email that was sent from Ms. Forrest Rain regarding precisely that there was a change of the applicable law. And also when we analyze why Ms. Bupati wanted to change the arbitration clause, we see that there wasn't a specific motive, and that motive was, I would say, answered or addressed by the new arbitration institution that were chosen under those terms. So I think that maybe we could also try to analyze the rationale, what were those changes, and whether or not Ms. Bupati was aware of those changes, and even though she maintained a practice or a conduct demonstrating that she accepts those terms. We can see that normally between the practice between the parties, if Ms. Bupati had any change to the terms or she opposed to those terms, she would say that within 1 week, and that was not the case in this VisMoot year's problem. Instead, there was the bank letter. Instead, there were communications between respondent and communications between the respondent and claimant to try to conclude the final version of the contract. So I believe those are interesting points to see as well when asserting the valid incorporation of the general terms.
Is it maybe a good time to flip in my short presentation on the inclusion of standard terms, which we had considered showing to everyone? I will make it very quickly, but maybe it's helpful for the issue. And then, what do we have? A half an hour left, or Daniel?
Oh no, yeah, we have an hour left. Yes. Okay. But yeah. Since we've already entered into the
the third topic is covered. So
covered.
You have all the time.
The incorporation of the.
I'm looking to you if you can now see my presentation, and you can still hear me.
Yes. Yeah.
Good. Very good. Yeah. Sometimes you don't know. Well, I think my thinking when I was invited to join the session was there seemed to be two federal Supreme Court decisions from Germany being quite prominently on display in this year's mood. The one is, of course, on the law applicable to the arbitration agreement, where an important decision was rendered that the CISG can be applicable to an arbitration clause in a CISG contract. And then there is this older decision, the machinery case, on the inclusion of standard terms under the CISG. So this is the decision I would like to focus on in this discussion. So that's the decision of 31st October 2001, and I have set out the facts very briefly here for everyone of us. So the case concerned the sale of a used computer control CNC rolling milling machine for the price of roughly 400,000 Deutsche Mark back then, including the making available of a mechanic for 1 day. Seller was located in Germany, buyer in Spain, and the seller had sent a confirmation of the order. The confirmation was made with reference to the standard conditions of sale and delivery, and the standard conditions contained an exemption clause excluding any liability for defects of the used equipment. The sale was for used equipment, so there was a reason for a full exclusion. The seller's mechanic could then not install the machine within 1 day. The machine could only be rendered operational with the assistance of outside expert on the buyer's cost. So the buyer sought to recover its costs incurred from installing the machine, and the legal question was, is the reference in the confirmation of the order sufficient to validly include the standard conditions into the contract? The German Supreme Court took the view that the inclusion of general terms and conditions into a contract that is governed by the CISG is subject to the provisions regarding the conclusion of the contract. So that is Adriana's point, right? The CISG does not explicitly speak about standard terms at all, but the court, in accordance with the majority view in legal doctrine, found that the general rules on contract formation would govern also the inclusion of standard terms, and that national law is excluded. And then the court went on to say that through an interpretation according to Article 8, it must be determined whether the general terms and conditions are part of the offer. I think that's so far so clear. And then it went on to say that there are two main requirements for a valid inclusion. The first requirement is that the intention of the offeror, that it wants to include its terms and conditions into the contract, must be apparent to the recipient of the offer. And in addition, the court required the user of general terms and conditions to transmit the text or make it available to the other party in another way. And that is the requirement that so famously featured in this case and also influenced the international debate on it and is heavily used in this year's analysis. It went on to say that it was easily possible to attach the general terms and conditions to an offer. And it would also be in favor, of course, of the offeror as the user of the general terms to benefit from them, especially in this case, the full exclusion, of course, and that it would contradict the principle of good faith, as well as the general obligations of cooperation and information, if there was an obligation on the other side to inquire regarding the respective standard terms, that would be an unfair burden on the party confronted by these general terms and conditions. It's interesting to note that, in my view, and that's maybe also something to be picked up by counsel in the mood, the judgment has a little bit of a consumer protection language in it. It's quite interesting to read, as you will know. The CISG is a B2B convention, and it has a certain definition of excluded contracts in Article 2, but that is not identical to European legislation on consumer protection, or in this case, German domestic regulation on consumer protection. So there's always a possibility of some friction, that also some sales that are considered to include a consumer under national law could also to some extent be governed by the CISG. And I believe that also that reason influenced the court a little bit in requiring stricter inclusion standards, because you don't have the opportunity to review the standard terms for content. Interestingly also, and also some ammunition for arguments, of course, is that this German court did not take into consideration other Supreme Court decisions from Austria that were rendered prior to that decision. And there are other cases out there, primarily from the United States, that take a more relaxed view on that requirement, and basically apply Article 8 of the CISG, as Adriana has already suggested. So one could say it's of course still a very controversial topic. Then maybe to help us understand the issue, you all know the Advisory Council of the CISG. It's a private body consisting of professors and practitioners who are very active in the CISG community, and they have rendered a opinion on the inclusion of standard terms, and they also take or give a more relaxed standard and say the party confronted with standard terms must have had a reasonable opportunity to take notice of the standard terms. So they deviate from the stricter requirements of the German Federal Supreme Court. Yeah, and then finally, and then maybe back again to our discussion, I have just noted a few thoughts I had. You see them here. I don't know whether we shall leave the presentation on for the moment, or otherwise we go back to the discussion mode. But I think here, yeah, the big question is a clear reference and sufficient for the inclusion, or was it an obligation of the claimant to really provide the text of the standard terms with the offer, or was there rather an obligation of the respondent to inquire if anything was still unclear about the content of those standard terms? And of course, we have again the issue we already discussed with actual knowledge of Ms. Bupati from her time with the mother company of the respondent. maybe I stop the presentation so that we are bigger on screens.
So in this case, you think it is relevant that the standard terms, they were referred to in orally instead of written. So they were referred to, and is it also relevant that the standard terms also changed slightly since they were made available to the representative of the party? Do you think that would be relevant, and in what capacity?
Definitely, because I think, you know, all the circumstances of the specific case needs to be considered under the mandate of Article 8. And certainly the fact that they even discussed them orally shows that they know that they are out there and had a basic understanding of the content and discussed certain changes for it. So it shows that at least Ms. Bupati, I think it's fair to say she knew what she was discussing about. And another question is, can that knowledge be ascribed to the respondent? And there, I mean, we had already a discussion. I think I did not offer my view. For me, you know, it's also a little tricky question legally, because you could also say, well, this transcending knowledge is not even regulated within the CISG, right? Maybe that is something left to domestic law, applicable, you know, to say the law of agency, or where you get your authority from. That is not governed by the CISG. So one could also make the argument it's not even within the CISG. I would rather see it the other way around. I think the CISG speaks about parties and must have considered that people are acting for parties. And I think also, you know, in the context of Article 79, legal doctrine seems to take the view that you're basically that from the fact that you are basically liable for your supply chain, to make it a little bit too easy now, that you could also infer that knowledge from employees or even subcontractors can be ascribed under the general principle underlying 79. So I would argue it is within the CISG, and then all facts are relevant and very difficult to decide, as Adriana has said, right? Whether it is really sufficient that the main negotiator has had knowledge.
Yes. So does the rest of the panel have any considerations on this matter of the incorporation of the general terms and conditions?
I'd like to comment on, perhaps, I think it's, first of all, thank you, Florian, for explaining us in detail the machinery case. I think it shows how important it is when you want to use case as a legal, as authority in your situation. You must pay attention to the details. You must need to pay attention to all the circumstances involved in that case. I would say that after your presentation, I don't see that it's impossible for us to reach different conclusions in relation to the machinery case in the case of the VisMoot of this year. It seems to me, in the first case, machinery case, quite interesting. You're talking about selling used products. Although there's nothing wrong with that, the mere fact that they are used, I think, does not deprive the vendor of the burden that those used products are working on a normal basis. You know, it would be I would assume said, I have some used computers here that I want to sell to Florian, but you need to ask some technicians to come and change this and that and so I think in your case, when you were explaining into detail, I would have reached the same conclusion myself. Obviously, they're all tricky cases, but you're selling used goods and they're not working. You still need to spend some money for them to be usable. It's a different scenario. Yeah. And I think it's also different in our case at hand, in the sense that the buyer had no previous, and the buyer that was negotiating the agreement had no previous knowledge of the general conditions. So I think one may establish perhaps the motives, if they in a certain debate they reach this discussion, it will be very enlightening or enrich for them to go through the two cases and show the arbitral tribunal that they actually are different. And there's no contradiction in using, in the decisions of both cases being different. Those are my comments. Thank you, Daniel, and thank you, Florian. Very interesting to learn from you this case.
I have one further question regarding the discussions of the order reference. I just may add that Article 24 of the Cisg states that for the purpose of this part of the convention, an offer, declaration, or acceptance, or any other indication of intent reads the addressee when it's made orally to him. So we have some reference to oral statements made between the parties, and that may be also be used by the teams in these years' problem.
Yeah, I think for me, I mean, we discussed about Article 14 before, and the importance of the goods, the price, and the essential terms of a contract. And if I'm not mistaken, they were there on that summit. The only thing was that Ms. Pupati needed approval. So it was actually an issue of authority, right? She said, we have it, subject to my management approval. And then the writing started, and the issues they already had discussed continue to be discussed. And the question is, how material are they? And are they material enough to stop a sales contract from being concluded, right? And there is a lot of overlap this year, and very difficult for teams to really make sure they speak about the right things at the right time. But we're not discussing now the agreement on arbitration. We are discussing the agreement on the sales contract, right? And there you could come to different conclusions. And it's a very interesting case, and contract conclusion is a very fascinating subject. But I totally agree with Adriana's conclusions. I think there is much room for legal argument, and when cases are used, really go into the facts. And I think there are quite a few broad US cases out there, so there will be other cases to use if you argue for an inclusion.
Yeah, and also another reference that could be made by the teams is that the Advisory Council Legal Opinion 13, it expressly mentioned the rule one of the rules is that there should not be surprising terms, because if they are, they shall not be considered incorporated. But in this case, I think it's reasonable to say that there were no surprising terms, because the change were explained by claimant, right? So that's one thing that I would like to add as well.
So going on to the third issue, and we already covered a large part of it, but just to make sure make sure we cover it in full extent. I'd like to ask Adriana if there is any legal support under the CISG to support the application of a common practice between people that can then bind the parties. Because as we discussed, the representative, he was a representative of the mother company, and now he's representing the subsidiary, and he's acting in much the same capacity and executing a really similar deal than he was before. So would you say that it could be binding? It could bind the parties? And after Adriana's considerations, I'd like to know the panel's opinion as well.
There is wording. I'm not sure it's 18.3, but I think there is wording, yes, on the CISG. Both criteria are important. If you can show usage between the parties, and the word is or usages in two different provisions. But I don't think, Daniel, this is the main issue, because we are not discussing, this is general conditions of the industry. Although we have prepared making this analysis, or have discussed a little bit, the real dispute is that, we don't have a practice between the parties. And are you going to use general conditions of the industry? If one of the parties can prove that, it's more than enough. Obviously, it's more than enough. And I think there is a legal wording on the CISG. But the fact here is that there are some nuances that probably would never amount to general conditions of the industry, that were known by a parent company. So my understanding is that we will go down into discussing whether the fact that Ms. Bupati knew herself, she was the negotiator, was enough, or if because of she does not represent the same companies, a total different entity, we should use the standard of machinery case. I think it's not probably the two separate solutions, normal usage could be binding versus a practice between the parties. It's a delicate scenario. It's a scenario saying, in relation to those parties, you have a different negotiator with knowledge of your conditions. It would be interesting also for us to discuss. Imagine that Ms. Bupati, imagine that the company that Ms. Bupati is working right now has nothing to do with the mother company. Nothing to do. Imagine that Ms. Bupati was sent to a competitor. But she knows the general conditions. She knows. So when Mr. I forgot his name, Chandra, tells her, you are working with this new company, has nothing to do with, but let's us use in our case the general conditions. So again, I would analyze it, the discussion, the analysis, it has nothing to do with usage of people, general usage in the market, I would say, but my analysis, my way of looking to it would be those two companies. Is there surprise, as Aécio mentioned? The buyer was surprised by the elements of the contract or not, or knew it beforehand, or we would apply this harsher analysis from the maturity case.
Mm. Yeah, it's a little bit a mind-blowing exercise if you dive into it, how we now do, and I believe that, you know, the Cisg talks about parties, so that and if the party is a company, you will always have people acting for the company, right? And of course you have national law, corporate law on, you know, whether those people have authority, whether they may and may not, and domestic law may also have express statutory provisions on the imputation of knowledge of employees to the company, right? So you could in one way say it's corporate law issues, so the place of incorporation should govern it, or you say, well, it's somewhat, I mean, the Cisg is concerned with the formation of the sales contract, with the terms of the contract, with interpretation questions, and Article 8 mandates an assessment of all relevant facts. And I would say that those facts should be at the heart of the analysis, and that they are to be considered. And then if the argument is not Ms. Party did not have authority, then, well, the respondent choose to be represented by her, she can make an oral agreement under the Cisg, and you know, no director at the at respondent would know about it. I mean, that's how the law functions, right? As long as she has authority and is the negotiator, then I would also say if she knows about those things for 10 years from another contract, there's no obligation on the other side to inform now the respondent. I would argue, but it's of course a very tricky one.
So, well, having covered, I believe, the three issues, if the panel doesn't have any other considerations as to the merits, so I'd like to thank our panelists today. I think it was a great panel, and I think the Moody's are in for a tough oral pleading. It's really contentious issues being debated. And this is indeed the third and last webinar in our series on this year's VisMoot. And today I have the pleasure of ending and thanking all the panelists, even in the other panels, the one covering the oral pleading, the oral arguments, and the one covering the jurisdictional arguments. Series of events, and I hope to see my fellow panelists and the other panelists all participating in pre-moots, and may this not be the last cooperation between the Young Arbitrationalist Committee with these most esteemed and generous panelists. Thank you for your time, and in case you have any other considerations, if you want to say goodbye, bid our audience adieu, feel free.
Well, thank you, everyone. It was a pleasure. Congratulations for this webinar, for the initiative, and I look forward to meeting Daniel and my dear colleagues in other opportunities soon.
Thank you very much for the kind invite again. I hope it was a little bit entertaining. All the best for the mood, and hope to see you all in Vienna one day. And of course, to Daniel and my co-panelists, I hope we get the opportunity to meet in person rather sooner than later. And wish you all a good day.
Thank you.
Thank you all. It was a pleasure to participate and to listen to you all. Thank you very much.
Thank you all. Bye-bye.
Bye.